Here to weigh in, though, on the breaking news of the day, Newsmax senior judicial analyst, Judge Andrew Napolitano. Judge, welcome back to National Report. Talk to us about what these 6 counts are, why it's significant today.
Emma and Sean, always a pleasure to be with you. So the Sixth Amendment to the Constitution requires that the defendant be familiar with and understand the charges against him. The government can't just allege vague or nebulous charges. It has to allege them with specificity. And Judge McAfee just ruled, quite a surprise sort of to all of us that follow this, guys, but he just ruled that for 3 of the counts against the former president, there was not enough specific information in the indictment to allow President Trump to prepare a defense against him because he didn't know exactly what they accused him of. This has to do with the now famous or infamous, depending upon which side of this you're on, phone call to Secretary of State Raffensperger, where the then president said, "I just need you to find some votes." Was that an innocent, please recount the votes to make sure there isn't a mistake? Or was that an act of corruption? Well, the government says that was an act of corruption, but they failed to say what aspect of the phone call was corrupt. So the government can do a couple of things. It can just forget about this because there are still 38 counts remaining against the former president. It could appeal it. It probably won't do that because that will take months and months. Or it could go to a new grand jury and recharge with the specificity that the judge says was lacking. Trump's lawyers were expecting that these counts would be thrown out entirely, but instead of throwing them out entirely, the judge threw them out without prejudice, meaning the government can go back to another grand jury, present what evidence it wants, rewrite those portions of the indictment with the specificity that the judge says Georgia law and federal law require.
And
That's
of course,
where we are this morning.
Right. And of course, what that takes is time, right, Judge? This is going to take time, and it sets you back again. And we've had these conversations here at the desk with you before about as time goes on, what that does to a case that has yet to be tried officially. We've seen, again, the district attorney, Fani Willis, in hot water overseeing this case. Will she continue to be able to oversee this case? Will she not? And with that process, again, delays this process. Now you have counts dropped. Could they be, again, brought forward in front of a grand jury, as you pointed out? Do you see it as that? Do you see this case breaking down as time goes on?
Well, Sean, the former president has made no secrets about the fact that he wants to delay all of these trials. He cannot be tried in a state court while he is the sitting president of the United States. So if this case is delayed beyond November, and if he is elected in November, which now seems to be more likely than not, it is almost inconceivable that the case would be tried at all in the next 4.5 years. Theoretically, he could be tried after he leaves office, but this is not the federal case where if he's elected president, he simply asks his new attorney general, whoever that might be, to dismiss the charges against him, which he has the authority as the president of the United States to do. So delay helps him by taking it off the table for election and getting it out of his mind for 4 years. Now, if he runs and doesn't win, or if something happens and he doesn't run, well, then he'd be prosecuted in the ordinary course, probably by the end of this year. I can't predict how long any of this is going to take. I might be able to have that prediction when I'm with you on Friday, when we expect the same judge, when you two guys are on air, to come down with the decision about whether or not Fani Willis and Nathan Wade stay as the prosecutors. Then we'll have a better handle about your very prudent question on time, Sean.